Sometimes, a dream that takes years to build can be shaken by a single letter in the mail or a question from an immigration officer. For millions of immigrants around the world, becoming a U.S. citizen feels like the final step, the moment of safety, pride, and belonging. But what if, one day, that security could be challenged? What if the citizenship you worked so hard for could be questioned, reviewed, or even taken away? Today, we're going to uncover the truth, calmly, clearly, and step by step, so you understand how U.S. citizenship can be lost, how rare those situations are, and how to protect the future you've built. In the United States, there are two main ways a person becomes a citizen. Some people are citizens by birth, either born on American soil or to U.S. citizen parents abroad. Others become citizens through naturalization, which means they first immigrated to the U.S., became lawful permanent residents, and later took the oath of allegiance to the United States. Both types of citizens share the same rights: the right to vote, to travel freely, to work, and to live under the protection of the American flag. But the law draws a subtle distinction between them. Naturalized citizens, because they obtained citizenship through a legal process, can have that process reviewed if serious issues come to light later. Let's start with the simplest and most voluntary way citizenship can end: renunciation. Renunciation means you personally decide to give up your U.S. citizenship. This usually happens outside the United States at a U.S. embassy or consulate. It's a formal process. You must appear in person, swear an oath that you are choosing to give up your citizenship, and pay a significant fee of over $2,000. Once that decision is made, it's final. You surrender your passport, lose the right to vote, and no longer qualify for government benefits. If you ever want to return to the U.S., you must apply for a visa like any other foreign national. Why do people renounce? For some, it's about taxes, especially Americans living permanently overseas who wish to avoid complex tax obligations. Others feel completely rooted in another country and want their legal status to match that life. A few do it for personal, political, or moral reasons. Whatever the motivation, the government treats the act seriously because once renounced, citizenship cannot be undone. Now, let's talk about the part that surprises most people: when citizenship is taken away involuntarily. This process is called denaturalization, and while it's rare, it's very real. Denaturalization happens when the U.S. government determines that someone should never have been granted citizenship in the first place, usually because of fraud or hidden facts during the naturalization process. For example, if a person lied about their identity, concealed a criminal record, or failed to disclose involvement in serious crimes or human rights violations, that concealment can form the basis for denaturalization. The government can reopen your file even decades later, 5 years, 20 years, or even 50 years after you became a citizen. Once a federal judge agrees that the citizenship was obtained illegally or through willful misrepresentation, the government can revoke it permanently. There are documented cases showing how this works. One example involved a man from Bosnia who had been living peacefully in the U.S. for years. When investigators later discovered he had participated in war crimes during the Yugoslav conflict, something he never revealed on his immigration forms, his citizenship was revoked. Another case involved a man who had served as a Nazi concentration camp guard. He had lived in America for decades until the government uncovered his past and removed his citizenship before deporting him to Germany. These may sound extreme, but they illustrate how deep federal agencies can investigate if they suspect fraud. Denaturalization doesn't only apply to those accused of war crimes. It can also involve individuals whose later actions conflict with their oath of allegiance to the United States. For instance, if within 5 years of becoming a citizen, a person joins or supports a group that promotes violence against the U.S., their loyalty can be questioned. Even if they never personally commit a violent act, association with such an organization can raise red flags. Serving in a foreign military that is hostile to the United States can also lead to problems, especially if the person takes a leadership or officer role. The reasoning is simple. When you take an oath to another country's armed forces, it may look like you've transferred your loyalty. Similarly, accepting a high-ranking political position in a foreign government can also be interpreted as abandoning allegiance to the United States, unless you had permission from the U.S. government before doing so. Many people then ask, but isn't dual citizenship allowed? The answer is yes. Under most circumstances, the U.S. recognizes dual citizenship. But the key word is intent. What matters is not just what passports you hold, but what you meant when you took that second nationality. If your goal was to give up U.S. citizenship, for example, if you swore exclusive loyalty to another country or accepted a political post that required renouncing other allegiances, the law can view that as a voluntary loss of citizenship. But simply holding 2 passports or being a citizen of another country by birth is not a problem by itself. Now, let's turn to the most extreme and rarest cases of all. Under U.S. law, a person can lose citizenship for acts such as treason, rebellion, or serving as an agent of an enemy government. These are extremely serious crimes involving betrayal or violence against the United States. If a person is convicted of aiding a hostile power, participating in terrorism, or taking up arms against the country, the courts can strip their citizenship through a formal legal process. It happens very rarely, but it remains possible. In some cases, such individuals have even become stateless, meaning no country on earth recognizes them as citizens. Here's something most people don't know. The Department of Justice has an entire denaturalization section within its civil division. This team works closely with the Department of Homeland Security and Immigration and Customs Enforcement, known as ICE. Together, they use fingerprint databases, digitized records, and modern technology to re-examine old naturalization files. They sometimes go back 30, 40, even 50 years to verify that citizenship applications were truthful. If they find false statements or hidden information, the Justice Department can file a lawsuit in federal court. Denaturalization is not automatic. It goes through the courts, and every person has the right to defend themselves. You can present evidence, call witnesses, and be represented by an attorney. But if the judge agrees with the government and signs an order, the result is final. The individual loses citizenship, loses the U.S. passport, the right to vote, and even the right to remain in the country. You don't go back to being a green card holder. Under the law, you become removable, just like any other non-citizen. So what about people who were born in the United States? Can their citizenship ever be questioned? For almost everyone, birthright citizenship is completely protected by the 14th Amendment to the U.S. Constitution. If you were born on American soil, you are a citizen, period. However, in very rare cases involving fraud, for instance, if someone used false documents, fake parentage, or participated in organized birth tourism schemes, the government can challenge that status. These situations are uncommon and very difficult to prove, but they remind us that citizenship records must always be truthful. Across all of these examples, one word explains everything: intent. The government cannot take away your citizenship unless it can prove that you knowingly and voluntarily did something to lose it, or that you obtained it through fraud. The burden of proof is heavy, and the number of successful denaturalization cases is small compared to the millions of honest, law-abiding naturalized citizens who contribute to this country every day. Still, understanding these laws is important, not to create fear, but to create confidence. When you understand the system, you protect yourself. You know what actions to avoid, what paperwork must be truthful, and what loyalty really means in the eyes of U.S. law. American citizenship is one of the strongest legal protections a person can hold. It opens doors to rights, opportunities, and safety, but it also carries responsibilities, honesty, integrity, and respect for the country that